Kirk is not an attorney. This is not legal advice. This is to be considered for educational purposes only.
Welcome to Kirk's Law Corner Live with your host, Kirk Pendergrass and John Gentry. Hello, John. How are you?
Doing good, Ted. Thanks for having me on again. How you doing today?
I'm great. Thank you. So Kirk is going to be with us in just a moment. You have a few things that you want to go over.
Chris Hallett will be joining us a little late tonight. The state of Florida is loving the work that he's doing, and so he's meeting with some of the folks in the state of Florida this evening. So he's running a little bit behind. So we'll be excited to hear what he's got going on later on. But I'm gonna run through and start off, or maybe Kirk's gonna jump on now. Kirk, you want me to run through this now, or you want to jump on for a bit?
Well, I was thinking we'd get the shares out there first and build it up a little bit so we can get a good group going here. Because what we're added to this here is we're actually starting to show people how to write their documents. So this is good information. So
yeah, we're gonna, just for the viewers out there, we're doing on Monday nights, changing up the format a little bit, and we're trying to keep them like around 3 minutes, but we never do. But we're going to do, little 3-5 minute segments on some really good information about how to file specific documents. Tonight, I think you guys are really going to enjoy. We're going to do a section on how to do legal research from my experience, and I've working against some really tough lawyers out there, and I've learned a lot from it, and I kind of want to share that with you guys tonight. And also we're going to go over how to file a motion to recuse or disqualify a judge, and those will get pushed to Kirk's Law Corner YouTube channel, so you guys can refer back to them on the YouTube channel. Little short 2-3 minute, 5-minute videos that are highly informational. So get on Kirk's Law Corner YouTube channel and subscribe to that. So should I run through this now, or do you want to?
No, we'll wait.
Okay.
So good evening, folks. We're missing Chris right now. He's probably on the phone in a meeting. So
I think
he's just going to run through some deals here to kind of help explain, back in 1775, when everything was going relatively good from, 1603, when we came over here and the English came over and established Jamestown, Virginia. Lord James came over with all his wealth and established Jamestown, Virginia. And things were going good there for a while, up until right there, mid to late 1700s. So, part of our ideology here is the Declaration for the Causes and Necessity of Taking Up Arms. But what I want to specifically talk about here in this declaration, first of all, this is the first one in our ideology, which is where the Second Amendment comes from. But the reasons why, and it's exactly what's going on today. In the beginning of this, they're talking about everything was great. We gave support to the crown, and we had good relations, and everything was going really good. And then, let's see, these devoted colonies were judged to be in such a state as to present victories without bloodshed. and all the easy emoluments of statutable plunder. Okay, the uninterrupted tenure of their peaceable and respectful behavior from the beginning of colonization. Their dutiful, zealous, and useful services during the war, though so recently and amply acknowledged in the most honorable manner by His Majesty, by the late King, and by Parliament, could not save them from the mediated innovations. Okay, Parliament was influenced to adopt the pernicious project. Parliament was, okay, and assuming a new power over them. This new power, let me get into that new power, have in their course of 11 years. So over the last 11 years prior to July 6th of 1775, it had slowly been degraded in this, this pernicious project. Okay, given such decisive specimens of the spirit and consequences attending this power as to leave no doubt concerning the effects of acquiescence under it. They have undertaken to give and grant our money without our consent. Though we have ever exercised an exclusive right to dispose of our own property, statutes have been passed for extending the jurisdiction of courts of admiralty and vice admiralty beyond their ancient limits. So July 6, 1775, this is one of the reasons right here that they were having problems. This is that pernicious project that came up, this admiralty jurisdiction that they created. Statutes have been passed for extending jurisdiction of courts of admiralty and vice admiralty beyond their ancient limits. So there it is, for depriving us of the accustomed and estimable privilege of trial by jury. Do we have that today? Do we have anything going on today where you're charged with something, a statute that's not founded in law, because a statute is found in the code, and the code is supposed to codify the law. The law. Okay? Statutes are not supposed to be the law. So this is the same exact problem. Okay? This is right out of my Annals of America, Volume 2. This is, 1755 through 1783. And they're talking about admiralty jurisdiction right there. This is what happened back then. And we've, stuff that Chris Hallett talks about in his first original practitioner's judicial report was the return. We've come full circle, and we've returned to these parliamentary practices. And they're, Article 1, Section 9, bills of attainder, they're prohibited by law. To the federal government, that's Section 9. And then Section 10 is prohibited to the states. So this is part of the reason why the 9th and the 10th Amendment are written the way they're written, that there's other rights that are retained by the people, and they shall not be denied or disparaged. And then the powers not delegated nor prohibited, but they are prohibited, are they not? 9th and 10th, Article 1, Section 9 and 10, they're prohibited. Bills of attainder, that's legislation that prescribes punishment that bypasses your right to due process of law and your right to a trial by jury. That's what they were saying back in 1775. It's the same thing. So this is ultimately what I keep trying to tell people is this is not just family court. The whole all three branches of government have been overrun. And it all stems from the War of 1812. And in 1814, because we were ratifying the original 13th Amendment, which kicked the bar, get a little bit further into that, and they talk about this ministerial enemy. They didn't know who this ministerial enemy was in 1775, but they figured it out in the early 1800s. And they started, I've read some of the Annals of Congress. Now, this is Annals of America. Annals of Congress is just like the minutes and the notes from the meetings that they had, congressional meetings that they had. And in around 1807-ish, they talk about this impending doom, this impending war, because they were working on creating the 13th Amendment, the original 13th Amendment, which was kicking the bar, the Titles of Nobility Act. And see, this is also explains how law is supposed to be made through the Article 5. Okay, you have to have an Article 5 convention. And you're supposed to make law, an amendment to the Constitution. That's how it's supposed to be done, not through legislative acts. Okay, so they kicked the bar out of our country. You cease to be a citizen of the United States. And back then, citizen of the United States meant that you were an actual citizen of the United States, not this debt slave under the new 14th Amendment. Back then, that's, we get into the law of nations when we define those kind of words, because a citizen was actually someone of the father's bloodline of the people, one of the people. So, and that's defined in the law of nations. And then you have the free inhabitants. Those are people that weren't necessarily bloodline, but those people didn't have the right to be a president or to hold public office. That was part of the prerequisite, is that you actually had to be of the bloodline and be a citizen and have that political right to run for public office, so that we kept the American values stable and secure, that we weren't invaded. That's part of that invasion. Sometimes we think invasion means that physical force and violence is an invasion. That's not true. Invasion encompasses more than just the physical violence type stuff. Invasion means attempting to overthrow our form of government, our ideology, infiltrating our government, and which is what they did in the War of 1812. And they killed our representatives in government. They burnt our Capitol. Now we call it the White House, and it wasn't just a stone house. If we let that paint flake off of the White House, you'd see all the charred burn marks all over the Capitol. And they were attempting to destroy the ratification of the original 13th Amendment, which started as early as 1809 with the first state that had ratified it. So I have it on good authority that it was ratified. In 1814 is when they set fire to the Capitol. But knowing how the amendments are supposed to be made for the Constitution, okay, so the Congress would ratify it, put it to a vote, it's ratified to that particular point. And then the legislatures of each of the state must vote on it and put it in their legislature, their Congress, their public acts. So that was the hard part to dig up. And somebody out there did it. A bunch of people actually ran around the country digging in old books, finding books wherever they could find where it had been published by the legislature of that all of those states, in which at that time, according to the Constitution, you only need 3/4 of the states. So it actually happened, and it kicked them out, and that's what happened. They got pissed off, and they come in here. No. We have to have this admiralty jurisdiction. We got to take over your sovereign nation here, because we're not making any money off of you. And so in 1845, because they had killed our representatives in government and instituted themselves, which is a declared act of tyranny, right in the Declaration of Independence. Same thing that they talked about there in the Declaration of Independence, that they had instituted themselves in the power to legislate for us in all cases whatsoever. And that's exactly what they did. And by congressional act in 1845, it's in the congressional record, extended admiralty jurisdiction back onto the land. Exactly what we were separated from to begin with. Right there, July 6, 1775. That's part of the reason why there was the separation to begin with back in 1215 with the Magna Carta. Same thing right there with St. There. Religious separation. And they wanted liberty, freedom to do whatever they want to do. They wanted to be free, free from taxation, free from false arrest, false imprisonment. That writ of habeas corpus came out of there. So that's just kind of what I wanted to reiterate there, is that's what we're dealing with today, is admiralty jurisdiction. Plain and simple. It's I just talked to you about it there. I've talked about it before. I've given you the Congressional Act from 1845. I could find it. I've posted it a couple times. I can give you the exact citation. And then, it's not just family courts. And that's the problem. We're focusing on one little branch of a tree, and the root problem is affecting the entire form of government, because you get the legislative branch that creates these statutes and this policy, because we're supposed to create agencies by the consent of the people, right? And then the agency is supposed to make their internal policy that's supposed to apply to the agents of the agency. But then they've taken that policy. I've been going through my Idaho code, and like the protection order stuff, policy. And then they go over to here and say, well, it's the policy of the state, and the legislature makes these statutes. Wait a minute. Since when does the agency, which is, part of the executive branch, have the power to make a policy that becomes law that the legislative branch makes statutes off of? It's kind of backwards, backwards there. Getting that horse, or the cart before the horse there. You can't have the executive, that's separation of powers. I'm not supposed to have in the executive branch making law, public policy, or public law, whatever you want to call it. That's bills of attainder. It's not even bills of attainder, because the executive branch doesn't have that power to make policy as having the force and effect of law. But then having the legislative branch make policy, legislation off of policy, that is just repugnant. It is totally repugnant to the law and due process of law in the supreme law of the land, the Supreme Constitution, and even state constitutions. That cannot happen. That's repugnant. And then to have the judicial branch not do their job and provide us with due process of law, due to separations of powers. Why do you think they want to keep us from having trial by jury? There's a thing called jury nullification. It's part of that all political power inherent in the people, and they have the right to alter, reform, or abolish anything, capital T, at any time. And so that's part of the reason why the trial by jury is that way, is so the jury actually judges the facts of law, the law in question, the statute that's in question. Is it in accordance with the law, or is it repugnant to the law? Is it repugnant to the Declaration of Independence? Is it repugnant to our rights? If so, the jury is supposed to have the power to abolish that. Plain and simple. So another thing I'd like to touch on is the latest stuff going on with Trump. It's kind of funny how this whole FBI runs in and seizes all this information under search warrant apparently, or whatever. Now, if I recall correctly, there back when it was Clinton's time to have her servers seized and all of her devices seized, they had sufficient amount of time to go over all of the emails and only release what her attorney and her decided, because of security, right? National security. So why is it any different for President Trump? Not only that, due process of law requires that you already have the evidence you need to procure that search warrant. You can't just sit there and say, well, we think Trump did this and we're gonna just come in there and seize everything. No. Fourth Amendment specifically says what? We have the right to be secure, person, places, houses, and effects from unreasonable searches and seizures. Must describe the person, place, or thing to be searched or seized. So that warrant should have been very specific at exactly what they are searching for, not just a blanket search and we're just going to come in and take everything and then we'll go through it and then we'll decide what we're going to use against you. That's not how law works. It's not how searches and seizures work. It's not how a warrant for a search and seizure works. That would be Title 5, United States Code 556 and 557. And that's all also under the exclusionary rule, fruits of a poisonous tree. That's the fruits of a poisonous tree doctrine. You illegally, unlawfully search and seize something. That's no good. So I can guarantee you that's all going to get flushed right down the toilet just by the process that they did. And then get into the bombing over there. Now, this is something was even actually on the mainstream media. I was watching some late night TV stuff, and something breaking news came on the TV, and I'm like, what? Oh man, we just bombed over there. Okay. And they flat out said that Trump had worked with several different people, including Vladimir Putin, talked with Russia. Okay. And the thing is Russia said, okay, we know what you're up to. We know what you want to do. So that means that Trump worked with Russia. And Russia said, okay, we're turning off of our radar systems. We're not going to track your missiles. We're not going to interfere with what you're doing. We're also, Trump worked with them to let them get their soldiers out of harm's way. Okay, so these were supposed to be chemical weapons plants. And here's the twist. This wasn't actually Assad that did the chemicals attack. This is back to the deep state. And this is part of what you won't hear on the mainstream media. But the reality is I guess I'm just going to pose this as a question. Do you think it was the deep state, CIA, ISIS type people? Now, I don't know if there was actually a sarin gas attack or not. I've heard both sides say yes. One side say yes and one side say no. But the reality is it wasn't Assad. Again, we go back to the deep state and what's actually going on out there. And this is what's happening to Trump right here, because he wants to drain the swamp. He wants to get rid of him. And if you're not aware that the CIA is actually, the international drug cartel, they're the ones that are trafficking drugs. They're the ones that are trafficking the humans. That's what's going on. They're trafficking arms. That's that part of that arms scandal from Benghazi, that crate of rockets that ended up over there. And somebody didn't know how to arm the rocket. When they launched it and shot it at a helicopter, it didn't discharge, and it landed inside the helicopter. And they were able to track the numbers off of that rocket and tracked it back to a crate of rockets that, I don't know, was supposed to be still in military control, but that was during Obama's regime. So that goes back to all those emails, using BleachBit. And that's the other thing. There was 3 servers. If you watch the House Oversight Committee hearings like I did, there was actually 3 servers and like 6 devices that she smashed with hammers. Those devices. The other 2 servers, they just kind of like went out of the picture. And then the other one was they used BleachBit on, trying to, wipe the drives clean. And then again, they were able to get some. And then it's like, oh, well, we're going to go through that, and then we'll decide what you guys get. So that's kind of what I have for the latest stuff going on with Trump, other than I'm telling you, come January 1st, 2019, military tribunals are being put together per the omnibus bill. That was in the omnibus bill. Money to make that all happen, and that puts the proclamation, which establishing the rule of law, back in place December 8th, 2017. Then we have the executive order from December 20th going after serious human rights violations and human trafficking. And there's section B to human trafficking, so look into that. That's the debt slave part. That's the money part. So like child support and fines under bills of attainder, that's all human trafficking under section B. And then the executive order that he dug up from 1984, allowing the military to make arrests, okay? And what we need to understand is this is what he amended and put it back out March 1st, is the fact that we can arrest civil servants, not us here, the people, not us, the free inhabitants, civil servants. That's the wording that's in the omnibus bill, to try them in military tribunals. And Trump flat out said, those of you that are involved in the serious human rights violations and human trafficking may end up being sentenced to death. He's even talked about the pharmaceutical companies, the doctors that are poisoning us with those pharmaceuticals. He's talked about the CIA, the FBI, the EPA. We're talking the whole thing, everybody. And this stuff doesn't apply to us, we the people, the free inhabitants here, the free people. He's talking about public servants. Flat out, that's what it says. So that's what's coming January 1st, 2019. And you can bet your sweet potato out here in Idaho that that's what's coming down. And that's the reason why things are happening the way they're happening. They're all grabbing at straws, trying to figure out how they can stop our current president, President Trump. He is our president, whether you like that or not. That's what's happening. So for those of you out there that have been waning and thinking that he's gone off and he's being controlled and he's just a puppet, and it's funny because now I'm starting to hear more and more about this. He's playing a game of chess, and I've been talking about playing a game of chess for freaking 5 or 6 months now. And that's what it is, when you're talking about the deep state and how corrupt they are. I mean, are people aware of how many bodies just come up, I don't know, suicide, shot themselves in the back of the head twice, or out on a fishing trip or whatever and commit suicide in their own bed in the motel room? How is that? And some of these people are ones that were going to testify against Clinton about Benghazi Gate, Pizzagate. It's just kind of just a mere coincidence that these people that are going to testify commit suicide. That's all I got about right about there. So I'm going to turn it over to John Gentry, and we're going to do some education here. We're going to teach you how to write some stuff, get yourself in court, and how to effectively defend yourself.
All right, so we're changing up Monday nights a little bit, and we're trying to do. So Ted is going to record a little short segment here. I'm going to try to do this in 5 minutes or less, and I'm going to first run over how to do legal research and why it's important. And you guys can refer back to this stuff, and I invite you guys to go to Kirk's Law Corner YouTube channel and subscribe there. And these little short videos will be posted there, not just for sifting through 2-hour talk with us on this show, but you can go refer to those at any time. And I think, other viewers will find those really helpful out there. So you guys, if you know people involved in this movement who are fighting for their rights in court, refer them to that YouTube channel. It's going to be a great education resource for you. So Ted, we're going to do, let's call this one legal research. And you ready to go? Ready to start recording? Let me know when you're ready. Okay, all right, so mark the time now. Okay, you guys, legal research and why it's important. I can tell you without a doubt, my attorney conspired against me. So whether you are represented or not, I think it is critical that you do legal research. Look up the cases that your attorney is citing, and for damn sure, look up the cases that opposing counsel is citing, because I think 99.9% of the time, they are misrepresenting opinion from higher courts to support their position. And you can prove that, and then you can go to your attorney and say, get off your ass and rebut this in a memorandum of law, because the memorandum of law that they cited is full of crap. And I'm going to give you guys a couple quick examples here and share my screen with you. And then I'm going to go over really simple tools that are available for anybody out there to do legal research and how to use those tools. So I'm going to share my screen here with you guys. So this is actually an opinion I just got back March 26th. And in district court, I had requested an evidentiary hearing. And so the Sixth Circuit came back and they said, Gentry contends that the district court should have given him an evidentiary hearing before dismissing his complaint. And they said the circuit has long held, however, that a district court does not abuse discretion by dismissing a complaint without first hearing oral argument. And then they cite this case. And most people, what they do is like, oh, darn, there's this supporting authority that says they don't have to have oral argument and I don't get to have an evidentiary hearing. And they just give up. And they assume, Sixth Circuit, these are honest judges citing the law and they know what they're talking about. I never accept what they tell me. I object to everything. I research everything. I encourage other people to do the same. When I do the research on Klein v. Rogers, and let's go take a look at that case. I have found it's been more than adequate for me, Google Scholar. So I've got a bookmark here, Google Scholar Fed. And can you see this screen, Ted? Can you see that, or is that too small? Let me see if I can bump it up. Can you see that top left of the screen, Ted? Yeah, okay. So the first thing you're going to do is select your court that you want to do research in. So if you're in Alabama and you're in state court, you want to cite Alabama Supreme Court as supporting authority, and maybe the Court of Appeals. So you come in here. So again, I go back, top left of the Google Scholar screen, and I click Select Courts. And if I'm in Alabama, I'm going to click the Court of Appeals and the Supreme Court and click Done. And then I'll come back here and I'll look for if opposing counsel cited a case, I'll type in that case. If it's my own counsel, you know, that cited a case, I'm going to go see if they know what the hell they're talking about, and I'm going to double check that case. Or for example, I was involved in litigation about a business, and so I just went out and looked I just searched the word business and started sifting through the cases to see what the Supreme Court had ruled. And I might use two words like business and divorce, for example. But let's go back and let's look at this and look at federal courts. So I'm going to clear all here and select the federal courts. And then I'm going to look for that case. So that was Klein v. Rogers. It pops up for me. And sometimes what they'll do, is they'll put in the paragraphs where it's referenced or something. Some of these, sorry, my dog is excited. Some of these will be part of the case citation. But you can scroll, these paragraph references are listed in here. And if I do a Control F, and Control F, you guys, is your friend. You got to do, Tasha. Control F is your friend when you're doing legal research. You know, and it brings up a search box here, and I'll type in hearing, and it takes me right to it, and it says, although Klein argues that district court dismissal was premature, and he should have been allowed oral argument. And then this is what keyed me in, is they're saying that this is based on Rule 78. And Rule 78 it started out in 1939 when there weren't any district courts. You know, we didn't have federal courthouses all over the country. And so the Federal Rules of Civil Procedure, Rule 78, said that the district courts shall have a day to hear motions. It was called Motion Day. And it said if they want, they can also, by rule or order, set up a day where people can submit briefs to just be decided upon the briefs without oral argument. And I think here the Sixth Circuit has misapplied an administrative rule used as a basis to deny due process. And so, you know, I don't, you know, they're saying it's an abuse of discretion. I'm arguing that it's not an abuse of discretion. It's a denial of due process. So Google Scholar, man, you guys, this is so easy to use to search your courts. You can also search for recent cases. You can set the time frame and say, you know, everything since. I'll tell you, if you're looking for due process, it's all like 1950, 1960 and earlier. The Supreme Court has totally flip-flopped on the essential elements of what due process is since 1960. Prior to that, you know, our courts were fair, you know, and having an impartial judge being able to present your evidence and your testimony, being able to confront adverse testimony, those were all essential elements of due process. The Supreme Court today doesn't talk about those essential elements anymore. So I like, you know, setting my range to find relevant stuff for me about due process earlier. So great source. I'm going to go, when I look up USC, I just go to Google and I'll type in 18 USC 1983. And what I always look for on here is Cornell. And so I always, when I'm looking up USC, I always go to Cornell.com. It's one of my favorite places.
Mine too.
And when you're in Cornell here, you can flip back and take a look at the whole chapter, and you'll find you know, maybe something more than you were looking for by going back in through there. So to kind of summarize this, do your legal research. Check what opposing counsel cases that they're citing. I want to bring up another point about going into Google Scholar here. I forgot to mention. Let me jump back into a case here. Federal courts. I'm going to look for one of my favorite cases. Mitchum v. Foster is one of my most favorite cases. But when opposing counsel cites a case, these guys are like my own paralegal team. Opposing counsel is my paralegal team. I love them, the cases that they cite, because when I look these up in Google Scholar, they always have other cases cited in there on the same subject matter. And so you'll see all of these other cases that are listed in here. They're all hyperlinked on here. And you can bounce around and see what the Supreme Court said in that case. And so, you know, when opposing counsel cites a case, that case is relevant. Most of the time, it's at least somewhat relevant to your case. And so they do all your research for you and they get you pointed in the right direction. And then you just go through and that case will have more case citations, and you just start bouncing through these cases and picking out, you know, and again, Control F, and that brings up my little search box here. And then I'll type in, you know, whatever the keyword is that I'm looking for. Or if they cite a case and let's say in their case, they use the sentence criminal laws. And so I don't want to search through this whole damn document and see, you know, where's the sentence that they talk about. And so I'll come in here and I'll find a sentence out of their citation. And it takes me right back to that place. So Control F is your friend. Research the cases from opposing counsel and check these hyperlinks inside the cases. These guys do all your research for you. And it's a really great way to check up on your attorney and opposing counsel. 99.9% of the time, opposing counsel is misciting cases. So always look up the cases that they cited. All right, that's it for that, Ted. You want to mark stop?
Just wanted to say hi to the peeps out there that are tuned in tonight.
Do you guys want to share, like, do you have anything different you guys do for research? And Ted can append it if you want to mark the video now.
Yeah, check this out. Let me pull up my deal right here real quick. And I'm going to use Mozilla. I'm not going to use my, well, I suppose I could. I'm not running it. Oh, of course. Firefox wants to do updates. Let's go to Google. And I'll do screen share. Whoops, maybe I went too far. Come on. There we go. And share. I definitely like going to law.cornell.edu. I have it as my #1 bookmark. Then I have Idaho statutes, Idaho Constitution, Federal Practice Manual, a link to my our documents, then Idaho court rules. I have a whole bunch on my bookmark bar, but what I like about this site is it has the annotated Constitution. And you can do direct right here, but part of what I like about it here is, see, in the Constitution here, I have it set to go straight to the Constitution. But everywhere here where it says see explanation, it gives an explanation from the annotated Constitution, which you can go right here at get the law. And I thought it was right here. I thought you could actually go right to it. I actually thought you could go right to it from right there. But one way to get to directly to the annotated Constitution, one thing I like to show here, where is the Ninth Amendment? Ninth. See explanation of the Ninth Amendment, non-enumerated rights. Go to see explanation. And you end up with some bunch of stuff here. This one has just basically two to three pages here, so it doesn't really matter. Click on any one of those, brings you to the whole thing. But this gives you, footnotes, just like reading legal stuff. This gives you your page number. So right there, we're on page 1504 of the annotated Constitution. They talk about here, James Madison talks about the reason why we should have a Bill of Rights and why we shouldn't. He was trying to remain neutral. But one of the things was talked about in here was that there's so many rights. It was hard to enumerate some. And again, back to the same theory of if we enumerate some, the government will twist it into believing that those are the only rights that we have and the government has control over the rest of them. And that was part of the reason why the Ninth and the 10th Amendment were written the way they were. Not to deny or disparage other rights retained by the people. So this is where I try to talk about is getting into claiming your rights, because the claim and exercise of a right cannot be converted into a crime. That's Miller versus U.S. So the thing is here is we get to say what the law says. We make our arguments. We claim our rights. And then they're supposed to decide or no, yay or nay. That's that whole umpire. And even then, when you're talking about trial by jury, you're supposed to make your arguments how you see fit. And one of the key words here is I think, because that is the internal dictates of the mind, which is Constitution. So according to your Constitution or my Constitution, I have the right to travel by automobile, my carriage, my car. The funny thing is my car or truck, my carriage, because that's what's short for carriage is car, is rated in horsepower. And I have several Supreme Court cases that say that we have the right to travel by horse-drawn carriage, wagon, or automobile. So that's just a right. And the claim and exercise right cannot be converted into a crime, but you have to know how to claim your rights. And then, but this is, and it gives you right here, here's your cases. United Public Works versus Mitchell gives you the citation. And then right here, you could go, boom, and do kind of like what John was doing over there. You can go right up here. I'm going to pop open another tab. Right back to law.cornell.edu. Right over here in the search. Paste and go. If it's going to. There we go. And then all these cases pop up. So you can find stuff directly right on here. Any of those that fall under the annotated Constitution will be there. And those are, there's your footnotes right there. It tells you number 6, number 4. Now let's see, this was the first part. Rights retained by the people. Okay, let's go there, because this is the good part here. Well, no, I guess that's the same one, isn't it? But that's some pretty good stuff right here. And what I find interesting here is going back under the 6th Amendment, because that's kind of where your right to a trial by a jury comes from, right? And this is something I like to show a lot of people when I'm talking about succession of law. Source and rationale of the right to a speedy trial. Right to a speedy trial may be derived from a provision of the Magna Carta, and it was a right so interpreted by Coke, Lord Coke. Number 12, footnote number 12. Let's go down here to number 12. We will sell to no man, we will not deny or defer to any man either justice or right. Chapter 40 of the 1215 Magna Carta, and a portion of Chapter 29 of the 1225 reissue. Cloffer versus North Carolina. Now, I actually have this case. I downloaded it because of this right here. But the next one, much the same language was incorporated into the Virginia Declaration of Rights, 1776. Right here, and I've read from it several times. Okay, number 13. Get back down here. 7F Thorpe, which is exactly what my book says. But here's the key. Federal and state constitution, House docket number 357, 59th Congress, second session. I don't understand what the rest of that means. But 1909, basically, aside from 7F Thorpe, the federal and state constitutions under the House doc recognized the Virginia Declaration of Rights, which is kind of hard not to recognize it, considering it's the theoretical foundation of all government. That's the number 2 declaration in our ideology. That's the one that actually lays down our ideology of our fundamental principles, morals, and principles of law, because Christianity, that's where it comes from. That's where we get our ideology, our ideas, our morals and principles. But the fact that it's right here, and what I really want to point out is we're talking about the right to a speedy trial, right? Okay, but what about the right to a trial by a jury? It's so funny because when I go in here, they're thumbing around. They can't quite seem to find where the right to a trial by jury's at. Well, let's go and read what they're talking about right here under the right to a speedy trial. And it's funny because it's right almost word for word right next to it. This is section 8 of the Virginia Declaration of Rights, that in all capital or criminal prosecutions, a man has a right to demand the cause and nature of his accusation, okay, to be confronted with the accusers and witnesses, to call for evidence in his favor, denial of exculpatory evidence, okay, and to a speedy trial, okay. Now this is all one part of the sentence here in between the commas. And to a speedy trial by an impartial jury of 12 men of his vicinage, comma, without whose unanimous consent he cannot be found guilty. Now, for the life of me, they can find the right to a speedy trial, but in the same part of the sentence under speedy trial, they don't know how a right to a trial by jury works. It just freaking blows my mind. This is all in section 8, okay? And And if we understand how that is, without whose unanimous consent, he cannot be found guilty. It doesn't say unanimous consent to find you not guilty. This is the reason why you have to convince the jury beyond a reasonable doubt. This is the law. The right says, without whose unanimous consent, you cannot be found guilty, as it is written in law.
That's why I said, Kirk, that's why I'm like all day long. I'm like, my favorite question was burning. Did you go to law school? And if so, did you pass? What part of this do you not understand? Let's clarify that. I had the conversations today about judicial estoppel. Didn't mean to interrupt you there, but this is relevant. Because when you're talking about the right of due process and trial by jury, it's the process, right? Their guidance documents and all of that other crap that they've used to loop around the law. Remember that?
Right.
And one of the things that I do that they really hate, and it's actually in my follow-up report, it's equitable estoppel. Why did I choose equitable estoppel? Well, let's see. These are equity courts on the equity scale, right? So, when you talk about how you build your practice, okay, and in an equitable estoppel, this is the definition of the accepted practice of equitable estoppel. As a defense doctrine, preventing one party from taking unfair advantage of another when, through false language or conduct, the person to be estopped has induced another person to act in a certain way with the result that the other person has been injured in some way. Okay? Now, let's think about this for a minute. Taking unfair advantage. Well, where else have we seen the word advantage? In the definition of an emolument, right? The chair they sit in, right? So, in other words, we're saying, okay, because you're taking advantage of the inherited emolument, the thing you sit in, that chair. That's reason for equitable estoppel. And if that's not good enough, let's expand on that into estoppel by misrepresentation, right? We've discussed this one, an estoppel that arises when one makes a false statement that that induces another person to believe something that results in that person's reasonable and detrimental reliance on that belief. Well, damn. I just had a conversation with, that's why I'm late, with, I was paying attention to a conversation with, involving another client in another state. And basically this attorney, it's like, I wanted to ask her, did you go to law school? And if so, did you pass? How the hell could you advise your client to literally fall on their sword, especially when there's no evidence of number one, abuse or neglect, any evidence of any wrongdoing of any kind. And as a matter of fact, not only is my client not the one who's in contempt, the moving party is the one that's in contempt because of the circumstances of that case. So, and we can definitively show it. And here's where I'm going with it in my follow-up in that particular case. I'm also going to tag in from 1875, estoppel by negligence, which estoppel arises when a negligent person induces someone to believe certain facts and that the other person reasonably and detrimentally relies on that belief. So in other words, when the attorneys walk in and admitted jurisdiction and literally throw you under the bus, that's the action right there. You were led to believe, hey, I got your back. I'm going to represent you. I'm going to do this. I'm going to do this and da-da-da-da-da. And they don't do a damn thing. And after listening to that conversation tonight, I got to tell you, I mean, I was starting to kind of come around a little bit, but, there's still more of these actors out there. The question remains, did you go to law school? And if so, did you pass? What part of constructing a defense did you miss?
No. And I've added, you do understand that ignorance of the law is no excuse, right?
Oh God.
I added
We are
that.
brutal, aren't we, Kirk?
I did that in open court and on the record. So what I want people to understand right here is that this is what's called succession of law or lineage. Lineage is when you go backwards. This is succession of law. Now, what we have to understand about succession of law, rights cannot be diminished. So in this particular instance here that we're talking about, the right to a speedy trial may be derived from a provision of the Magna Carta. Imagine that right there. It may be, because it is, as it is written. And for those of you who don't quite understand, we brought the English brought the Magna Carta with them when they came over here, because that's what they did. We didn't have this stuff, like I said, back at the beginning of the show. 1603, Jamestown, Virginia. Sir James came over here and established Jamestown, Virginia. So he brought that with him. Now, in doing research here on law.cornell.edu, see right here, CRS Annotated Constitution. I mean, I don't know how I did it before, but I went right straight to just the Annotated Constitution. Right there, CRS Annotated Constitution, right here at the top. Once you get in there, you can click right on that and go right straight to it. But this is another great source of information and research, because when the annotated this has already been decided. This is another one of those things that's kind of laid down in stone, unless you find something that's repugnant, because we do have bad case law. But this is technically case law right here, the annotated Constitution, but it's supposed to be the golden stuff. When we're talking about we will sell to no man, we will not deny or defer to any man either justice or right. That covers a lot.
Well, remember, Kirk,
39 in there.
We have to remember that cases are not necessarily law, right? We have to remember stare decisis is examples of questions that the court has already answered. So
right, yeah, because rights themselves are law.
Correct.
And that's in Black's Law Dictionary, although it's seldomly used that way. Seldom. Well, as you can see right here, rights are law.
Hey, Ted, I want to put another piece in here. Can I jump in real quick?
Sure.
Hey, Ted, I want to append this to that previous video. Can you mark this and then make a note to add it to the end of the other video? Tell me when you're ready. I'm gonna go over doing some research on rules of procedure as well. Okay, ready, Ted, go ahead and mark and then cut this in. Ready, mark. Okay, so we just talked about doing research on Cornell and Google and the state rules of procedure and the federal rules of procedure are critical to research as well, and they're quite easy to find. If I just go to Google and I type in Tennessee rules of civil procedure, and I'll get a link that pops up here from TennesseeCourts.gov, and then here's all of my rules of procedure. And I'm going to give you guys a really, really good example of why it's important to look at the rules of procedure. So opposing counsel, after I went in for a hearing, they denied both of my motions without hearing arguments or anything. They just said denied. And opposing counsel files a party prepared order, and they award attorney fees to themselves. The judge didn't say anything. They just awarded attorney fees to themselves. And they said, and then when I complained about it, they said, oh, well, Mr. Gentry was sanctioned under Rule 11 for filing frivolous motions. And I'm like, okay, well, let's go see what Rule 11 says about sanctions. And so I go in here, and sure enough, 1103 sanctions. And I read this, and what there's a safe harbor provision in this rule, and it says a motion for sanctions made separately from other motions, and it shall describe the conduct to violate 1102, which means that I filed a frivolous motion, supposedly. And it says it shall be served, but it shall not be filed. Shall not be filed with the court within 21 days. So there's a safe harbor provision, and it's saying they have to give me a copy of a motion to sanction and say, we're going to sanction you. You can withdraw this motion or you can amend it, but if you don't do anything, we're going to file this motion to sanction you. And that never happened. Or the other alternative is on the court's motion, the court can say, I want you to tell me why this is not a frivolous motion and why it has merit. And that didn't happen either. And because I took the time to read the rule that they cited, I saved myself $188,000 that they were going to extort from me. And in the appellate court, they tried to get attorney fees in there too. And I went and read the rules, and I said, you can't do that. And I did my research on the law, and I said, this is nothing but extortion under color of law, what you're trying to do to me. And you can't do it. So read the rules of procedure. They're easy to find. Just Google your state rules of procedure. You'll find them and start reading them. And the crap that they come up with, the twisting of the rules that they come up with is ridiculous. So you guys, when they say, oh, they were doing this because of this rule, read the damn rule, because 99.5% of the time they're misconstruing that rule.
Right. Yeah, they like to quote rules offhand and hoping that you don't know actually what it says. On 24th there, I was like, hey, well, that's not admissible per Idaho rules of evidence rule, blah, 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 blah. And they were like, oh, what? Dig out the book. And,
it says so in the book.
Yeah, these guys, they come up with just crap, like the Sixth Circuit motion day, just because of motion day, we don't have to have an evidentiary hearing. It's like, gosh, can you guys really?
Well, and then their standard defense when you do beat them is you don't know the law.
Right?
Well, no, because
what?
this is how you defeat them, is especially on the rules. Because if in my case, because they actually did sanction me, or the attorneys sanctioned me, the court didn't. The attorneys extorted me under color of law. But because I went and proved that this is what the rule says, the appellate court actually reversed those attorney fees that were awarded by the trial court. That never happens with the pro se litigant, that you're able to reverse a trial court decision. And I did, because I did my research on the rules, and they violated the rules. These guys, I'm telling you, they can interpret the law as they want. But when there's a clear-cut statute, when there's a clear-cut rule and they violate it, you can back their ass up against the wall and say, guys, this is what the law says. This is what the rule says. Follow the rules, follow the law. And in my case, I saved myself $188,000 in trial court and probably another $50,000 in appellate court, like by holding their back and saying, here's the damn rule, guys.
Yeah, it goes back to our favorite part of, hey, government, what part of in a limited government, and you can't do that, did you not understand?
Right.
Because I can reiterate that for you, just so you know.
What part of a declared act of tyranny and a capital offense capital offense treason? Yeah, it's capital felony treason.
Right.
They did the same. They did another one in trial court. They said they brought up their witness and they said, Your Honor, we would ask for a directed verdict now. And so I went and read the rule of procedure on directed verdict, and I'm like, no, I get to cross-examine before the court gets to rule on a directed verdict. You can't have one-sided testimony. Follow the rule.
Well, and that's funny because they ask me all the time, well, why do you have the entire Declaration of Independence in your reporting? And I say, well, I'm going to answer that. There's actually two answers to that question. Number one, it is the authority that I have claimed, right, dating back to the beginning. The original report says we have come full circle in the judiciary, right? And because of these declared acts of tyranny, mock trials being among them, right? So as far as what the Constitution and, all of those other things that followed the Declaration of Independence, those are the things that are in question right now, based on what I do. So I'm starting claiming my rights under the Declaration of Independence, which ironically is before the bar in the Judicial Act of 1789. So I said, you know what? I'm going back to the beginning before you guys were seated in your inherited emoluments, those seats you're sitting in. So that said, we're going to go back to this and we're going to start over again, and we're going to do it the right way this time. And we're going to finish what was what exists in law and our style form of government. And I'm going to show you per executive order what you're missing. Because in the preamble, where it says provide for the common defense, that's supposed to be through the Department of State, right? It doesn't say provide for the common prosecution. That's the Department of Justice, right? That's for bad actors, right? So when you provide for the common defense through the Department of State, you see what I'm saying? That's where all of the resources of the state are supposed to go to defend the people, right? So I took this and I broke it down so simplistically. I put it in as far as admiralty jurisdiction, I put that into a math equation, which really pissed them off. But again, I don't care. So, this is where, I also claimed under Trump's executive order 13781, hey, I need help from the citizenry to help me reform the executive branch. Well, where is the Department of State? Oh, wait a minute, the executive branch, right? So this project has shown definitively how many states do not even have a Department of State. So is it any wonder you can't get a common defense under common law when you don't even have the necessary department that does that? It's supposed to do that. It's provided for you in law. We cannot provide for the common defense if we haven't built the thing that does that. It seemed pretty simplistic to me. But again, because the bar likes its little monopoly, all right, now we have to go through and play the horse and pony show and watch this whole monstrosity unfolding with Trump's attorney right now and how they raided his office. And, oh my God, you violated the sanctity of attorney-client privilege, and they're going to jump up and down and scream and cry and whine. So they got to do the whole theatrics of it, right? Because that's what they love. Their government, they love their theatrics. Right. So I'm sitting there, I'm just kind of like sitting back in my chair going, oh, you must be on paragraph 2 of the preface in my report. When I very, very clearly said, this goes back to, I'll read it for you. What may seem rudimentary to so many when in consideration of basic equal protections and basic due process. Basic equal protections and basic due process. Pretty clear language, right? Didn't lose anybody. Okay. As related to this practice are luxuries it has never been afforded. Well, let's see here. Why hasn't it been afforded a due process? Because that due process is supposed to be handled internally. So we ended up with this here good old boys club, and that ain't going to work. Sorry, ain't going to work, ain't going to happen. So, it's funny. The more I get into this project and the more down and dirty my hands get into the swamp, it's like, yeah, I feel like I got my hands into an engine. You know what I'm talking about, Kirk? Pull it up and black and gooey, and it's like, I want more, so, and that's kind of where I'm at with this whole swamp project.
You know that smell when you pull a head bolt out for the first time?
Oh.
I work on a lot of Japanese engines. Like we call that, my gearhead buddies for 20 years now, we call that letting the little Japanese guy out.
Right. You asked for it, you got it. Bend over, Toyota.
It does have a distinct smell. I mean,
yep.
You're talking 15, 20 years down the road, when you pull a head bolt out, the air that's trapped in there is the air that was in there when it was put together.
Right.
And it's 15, 20 years old.
It's like,
it has a very distinct smell.
Yeah.
But, with going back to the Trump stuff there, if it was any one of us, that'd be we're going to a suppression hearing. First of all, how did you obtain that warrant? Was it lawfully obtained?
Right.
And then, what does the warrant say that you can specifically grab? What are you searching and seizing? What are you searching for?
There's the answer, because they raided everything, right? Which goes back to, remember, the rules of evidence. If you're searching a house for a car, right? Now, we're talking about a car you drive down the road, okay? Just for the sake of the conversation here, not a Matchbox car.
Right.
So you get a warrant to search a house for a car, and you walk up to a desk drawer and you pull open the desk drawer. Oh, I found a bag of weed here. Guess what? You can't use it because, number one, it's not on the warrant, and number two, you cannot reasonably expect to find a car in a desk drawer.
And not only that, you can't even touch it because you're not there for that.
Correct. That's why I said. So that's where we include the exclusionary rule. So when it comes to providing the defense for Trump, it's going to be very, very simplistic. Okay. Number one, you can't reasonably justify going into and taking everything. That's called a fishing expedition, right?
Right.
You have to be able to walk in and definitively say, I need this, this, and this, and this. Okay. And through an attorney under the Professional Code of Conduct, you're supposed to be given a subpoena first. That never happened. Okay. So because his records were never subpoenaed, he was never afforded the due process to answer the subpoena. They just went
556 and 557.
Right. So this is what I said, when you watch this stuff play out, I'm just sitting there going, just dying laughing, because I've been doing work in this project for how many years now? So it's like, oh, you guys are just getting caught up. Go to page,
Right. And then the gal comes out after the hearing today because, what did they do for Clinton? How long did they wait after they had the warrant to go get the server and her devices? How long? I mean, it was like 12 to 14 days.
Right. Oh, you mean the matter? That wasn't a case. That was or investigation.
Right.
That was a matter, right?
What difference does it matter now?
Oh God.
But
we can't make this crap up, guys. I mean, this isn't us doing this.
Right. She comes out, the gal, she's there. What's her name? Anyway, she comes out and all for the press there, and we're going to get to the facts and the evidence, or we're going to, let everybody know. Let everybody know what?
Yeah.
That you two may or may not have had sex. How many years ago? And you're a freaking porn star.
Right.
It didn't have anything to do with the presidency. And then the people want to say, oh, well, he paid her $130,000 in campaign funds. What campaign funds?
Yeah. You mean from his own pocket?
And then not only that, you were paid to keep quiet about it. That's a
whether it happened or whether it didn't happen. Now you're in breach of contract.
Yep.
So again, selective inclusion and selective exclusion.
That's settling out of court. Hey, look,
Right.
I could bring this up, and I could maybe get you in trouble with your wife and make you look bad in front of the American people. So here's a lot of people just call it hush money, but it's
Right.
settling out of court. Look, fine. I don't want to have to deal with this. I don't want to have to court over slander and libel, whatever.
Right.
Okay. So we'll settle out of court for $130,000.
Right.
You're not allowed.
As soon as she accepted that money, that contract was executed.
That's right.
And it's been interpreted that way throughout judicial history. Right.
That's right.
So
because it was
don't give me this bullshit, whether you like Trump or whether you don't like Trump, that this is in any way the silver bullet. Because guess what? It didn't work against, any one of us. It sure as hell didn't work against Clinton. It depends on what your definition of is, right? So, don't make us pull the old Clinton defense out on you, because guess what? That's been done. So,
yeah, I was going to say, what about the old BJ there in the old with Mr. Clinton and Monica Lewinsky?
So,
Hey, can I do a quick one on this disqual recuse?
Oh,
we got a disqual. Do it. Do it to it, brother.
All right. Ted, are you ready? Okay, let's mark. All right. So I'm going to do a section now on how to request a judge to recuse or disqualify. I think I can say I probably have the world record on asking judges to recuse. My fight has been against the legal system and the judiciary. And when you're fighting the judiciary, you're not going to get a fair judge. You're just not. Justice Gorsuch said, any attack or criticism on a judge is an attack or criticism on all the brothers and sisters who wear the robe. And it's a fraternal code. These guys protect each other. So the only way that you're even going to remotely, I think, try to get a fair hearing is to ask these guys to recuse. Now, why do I think I have the world record? Well, I've asked 2 state court trial judges to recuse, 3 judges on the Tennessee Court of Appeals, 16 active judges on the U.S. Sixth Circuit, and all 9 justices of the United States Supreme Court, because there is a strong appearance that the judiciary will not police itself, and that they will not hold a judge accountable. So I think I'm probably 16, 9. I'm up around 30 judges that I've asked to recuse. So I think that's pretty much a world record. I don't think anybody has done that before. Oh, and a federal magistrate judge as well. So how do you do it? How do you request a judge to recuse? Let me share my screen here. So I'll go to, each state is a little bit different, but generally the rules around disqualification or recusal are on the Supreme Court rules. So I'm going to type in Tennessee Supreme Court Rule 10. I just happen to know that one off the top of my head. And it's 10B, disqualification of a judge. These are typically numbered the same. The rules are very similar across one state to another. So probably if you go to your Supreme Court website or your government court website, they're going to find the Supreme Court rules, and that's most likely where you're going to find the motion or how to do disqualification. And so they lay out the rules in here. It's got to be in writing, in a motion. You have to have an oath or an affidavit accompanying that document. to give you an example of what happened in my trial court case and why I asked that judge to recuse, walked into the courtroom one day, and the judge is like, all right, what are we here for today? And opposing counsel's like, well, I got 3, Mr. Gentry's got 4. And I said, Your Honor, if it's helpful, I got a list. And he's like, let me see your list. So I hand it to the bailiff. He hands it to the judge. And he's like, he starts looking at the list and he's like, okay, wife's motion for that, granted. Wife's motion for that, granted. Husband's motion for that, denied. I'm like, Your Honor, you don't want to hear oral argument? He said, no, I don't need to hear oral argument, Mr. Gentry. I get in here at 6 o'clock in the morning. I read all your motions. I don't need to hear your oral argument. And then he goes, what about these last 2 from Mr. Gentry? Do we need to hear these 2? Well, it's like, well, if you read it and everything, why are you asking opposing counsel whether you need to hear my motions or not? He didn't read anything. He just started issuing rulings off a list of the titles of motions that I gave him. I think there's the appearance of that. I can't say that for sure, but for the viewers out there listening, I think, most reasonable people would agree. So there was an appearance, and I do this appearance I use a lot, or plausibly, or this suggests, because you don't want to call a judge a liar. You don't want to call them corrupt, because that'll get you thrown in jail for contempt of court. So you say it very respectfully. There's an appearance that the judge didn't read my motions, suggesting an appearance of bias or perhaps actual bias. And so you write it up and you attach an affidavit to it, and you file that. So that's state court. In federal court, I'm going to type in, it's 28 U.S.C. Section 455. And again, go take a look at our video doing legal research. And there's some great information on there on how to research federal, state Supreme Court opinion, how to narrow down your searches. Some really great stuff on that video. So check out legal research video. But for federal judges, 28 U.S.C. 455, and it says any judge or justice shall disqualify himself where he has a personal bias concerning a party. And so, it's pretty clear that judges will not hold other judges accountable. In my mind, that's a personal bias. I'll give you an example here. This was filed into the U.S. Sixth Circuit. And here's a second motion to disqualify. And so in state court, can you see my screen okay here? No, I'm not sharing. Was I not sharing on the okay. So here's an example of a federal motion to disqualify. And so I put in here pursuant to 28 U.S.C. 455A disqualification. And if you're doing a state, you say pursuant to Supreme Court Rule 10B or whatever it is in your state, I would ask these judges to recuse due to facts strongly suggesting actual bias, loss of impartiality, denial of due process. This was in my case. You would state why you're asking them. And then you go through, and I cite some cases in here regarding in the Sixth Circuit, and I filter that down on Google Scholar, looking at Sixth Circuit opinions regarding disqualification or recusal of a judge. And I cite cases specific to the Sixth Circuit. So you notice I got Sixth Circuit here. And then I go through and I list out the reasons that I want them. And then at the end of the document, you put in your oath and get that notarized. It has to be notarized both in federal court and state court. You have to do an affidavit and have it notarized. I'm going to jump back to the state court rules, because this is really important here. In here, it says if there's an order entered, that the judge has to state in writing his reasons and basis for denying disqualification. And I think this is common across most states. They have to state it in writing, and they have to state why. My judge didn't do that. My judge just said motion denied. And so he violated the Supreme Court rule and did not state any basis for denial. And so that gave me a good appealable issue. So make sure your judge follows the rules on disqualification in state court, and that he states it in writing the way that he should, that, no, I'm not personally biased, or no, I don't have a personal interest in this case. He's got to say why. He can't just say deny. So that's it on how to request a state or federal judge to recuse or disqualify.
And this is where it gets real tricky, because when they pull this, like many of you, having been through this myself, I'm not exactly known as a quiet person. But just because I'm not jumping up and down on street corners, lighting things on fire, and, whatever the hell else these factions are doing, I'm loud and boisterous on paper. And, having studied government and know how government works, I know right where all the key places are to go in there and just, crack them one and take them down. And, in other words, it's like the claim of a right cannot be, converted into a crime. So when you walk into, well, I'm saying this metaphorically speaking, because I've actually walked in there, but just for the sake of argument, when you walk into Congress and you lay down a document under congressional rules, okay, this is the right. This is one possible way. Okay, these rules, 28 U.S. codes, or subsections 2201, 2202, and 2415. This is the proper way to redress your government, right? And all you got to do is learn how. And because it's strange that, I said, okay, well, if the court doesn't have jurisdiction, we've already went down that road, and this one says they don't have jurisdiction. You got a whole bunch of people standing there going, not me, not me. Well, where have I heard that before? Okay, who broke mommy's lamp? Not me, not me. So, I've been hearing this not me thing for a little while now. So I'm like, okay, well, I know where not me is. Not me is the guy who wrote the judiciary, or the ones who wrote the Judicial Act. That would be all roads lead to Congress. So that's how I ended up in Congress, just so everybody knows. So, you go through these administrative agencies, the loop-de-loops, and you're going to get told to kiss their butt. And, that's, the way they've written their guidance documents. They collect a paycheck to provide a service, but you ask for the service and they say, kiss my butt. Okay, I'm going over your head, and my footprints are going to be right on your skull. And guess who I know where that is? That's your oversight committee. So again, that's one of the reasons I chose the rules that I chose in my reporting, because if I have a problem with a specific agency and they don't want to do the job, where does your emolument come from? Aha, that's right where I'm going. Find the rule, go straight to Congress, go right over their head and work my way down. So, and that's just the way I've always done stuff. I don't start at the bottom, work my way up. I start at the top and work my way down. So, I just didn't realize there were how many of you guys out there having that same problem. So that's one of the reasons I started agreeing to doing these shows, is I said, well, hey, this is common, or this should be common knowledge. I got to share this stuff. So that's one of the reasons why I do this. And when I get answers, I bring them out here to you guys as soon as I find them. So, and back to the judicial estoppel thing, I said, look, under these various versions of judicial estoppel, where, as then the reporting equitable estoppel, since it's equity court, let's talk about the misrepresentations and the negligence under the bad guidance documents. Well, that's where we are right now, is we're having that conversation, about the misrepresentations or misconduct of counsel, and under these negligently written guidance documents that don't even comply with the law. They're literally reverse practicing what the law says. So, and again, proven that. So that's why I said that this project has actually turned into a lot of fun for me, because it's like, well, I'm back in the saddle. I'm doing my thing again. So,
Ted Palmer, I hear you out there, brother. Trust me, this is a worldwide epidemic. It is not just in Maryland. This happens everywhere. So this is the thing we need to understand here is we have to file our paperwork. We have to make our arguments. What we call this in, which is paperwork, and then on is the oral arguments. In and on the record, and more importantly is the on the record, because when we file an appeal, the appellate court gets a copy of the transcripts. So that's what they look at, the oral argument. So I keep trying to preach to people, get your statements in and on the record. I don't care what commissioner or whatever it is that you're in front of. It's always appealable. Mind your P's and Q's, make your record, say, all right, you don't care, you don't want to follow the law, that's fine. I'll just go tell on you. We'll go up to the next level here and we'll see what they have to say.
I want to address a comment that Ted just made. And he said, you can't win until civil war and treason hangings. That's not true. I do not believe that for a moment. I believe that peaceful.
Yeah. Oh, yeah.
Yeah, that was Ted Palmer who made a comment on there about that. The gentlemen on this show, we are all about peaceful reform. We do it through the courts. We do it through the legislature, appealing to Congress. And we believe that we will have some success. And I know that Chris is having some success in Florida. He's getting heard in U.S. Congress. I'm having limited success, but I'm fighting some big guys. I got eight attorneys against me, and they all bill out at $450 to $600 an hour. But I'm giving them a run for their money. And, I haven't lost a case yet. I've got 2 cases in the United States Supreme Court, getting ready to file a 3rd case in the United States Supreme Court. And I trust in my government to do the right thing eventually. They don't want to. They want to protect the corruption that's going on. But I think that if we come together as a nation, as a people, and we stand up and say, stop this crap, you guys are destroying this country, you're destroying lives, I think that they're going to hear us. And I sincerely believe in my government. I believe in our system of justice. I don't want bad actors to go away. I don't care. I know probably the other guys will disagree with me. I don't care if they go to jail. Some of them need to go to jail, no doubt about it. But man, I would just be happy if they'd start acting right,
Well, and it's funny you say that, John, because, the more we, for lack of a better expression, when I say stick to our guns, now I don't mean bang, bang. I mean, stick to our, our conviction.
Clarify that.
Stick to our conviction, stick to, what we believe in, our ideology, that kind of stuff. It's a matter of, we're going to get there, which brings me to a very interesting point, which you were just discussing. when you go before a federal court and you ask a question, okay, just because they don't say judgment granted to you as the party, okay, doesn't mean you lost. They can answer your question and dismiss the case at the same time, right? Because there is a maxim of law that basically states it serves no purpose to create a precedent when you solve one problem by creating another problem, right? So when you talk about core concepts of practice, okay, knowing that these problems are complex, right? And there is a potential for the reverse practice of everything we do. It's not a matter of when you walk in and they say, okay, we're dismissing, here's the orders and our opinion. If you get orders and an opinion that you can decipher and that you can follow, right? And that ultimately lead to the thing that you're after. In my case, my first case led to me getting my practice. That was what I wanted. I said, I'll tell you what, I know it's my right to redress government, but I can't do it from this position. Okay. I need to be in this position. And here's how I do that. And I gave them the information and they said, okay, fine. You know, it's not like you're asking to walk out and shoot anybody. Okay, no problem. Here, we'll give it to you. Show us what you got, kid. That's what I've been doing. And, you know, I haven't gone in and said, other than in one particular case where I've basically claimed, you know, hey, look, we went ahead and said, because we could definitively show, well, this was the case I'm talking about today, the follow-up I did. We had definite bad actors. We had an incarceration. And I said, you know, hey, look, this is definitely an 18-241-242. It is what it is. I know the civil 42 is an 85-86, which is supposed to be the same thing as under civil as criminal. But under the circumstances, we have a clear trespass, and all of the actors just so happen to be bar members. And no, I don't like this any more than you do. So, and in fact, I've had to prosecute the prosecutor. And, you know, what do you do about that? And the answer is, it's not a matter of, is the court in disrepute or not? Yes, it is, or I wouldn't be here. I'm asking you how to help me fix it. And when it was a matter of, that's why I said it's not so much the question, it's how you ask the question and what you do while you're asking the question. So if you go in and you're flailing and you're this and you're that, and this one's a piece of shit and my ex this and this one over there that, probably not going to get you very far. So that's why I tell everybody, kind of keep those little things short, you know. That's why I publish this stuff. You know, when you talk about how do I keep it short? How do I keep it sweet? And the answers the answers are in the question. I'm going to show you an example of a couple in this statement of facts that I basically created here, where I just pretty much, it was very, very simple, right? You know, it's a just very short sentences. I mean, you know, the 1-2 word sentences, nothing major. It's common knowledge dictates that all professional practitioners must be registered with a licensure under the appropriate state bureau, and that licensure must be maintained to a state and or federal standard which applies to that particular field of practice. So I said, this is just me talking about, hey, common knowledge here, right? This is not me saying that this one's a piece of crap or that one's a piece of garbage or blah, blah, blah. You know, and it's little things like those that present you as, you know, look, I'm not standing here, you know, I know that's what this guy's saying that I'm doing, but I can not only just show you, you know, I can not only tell you that that's not what's happening, I can definitively show you that that's not what's happening. And that's what I've been doing across the board, definitively showing them that that's not what's happening. And now it's like, oh, Lord, you know,
I want to hit a couple.
This is why the inherited emoluments are in jeopardy. And that doesn't just mean the office of the White House or the governor's office. That means every congressional seat, every judicial seat, and of course the executive seat. So, it's like we know what those things are. After extensive research, it's like, okay, yeah, we know what that thing is called. Now, how do we fix it? So, here's my suggestion.
I want to hit on a couple points here, Chris. I love your point that just because our cases get dismissed doesn't mean that there isn't going to be change.
Right.
I love that point. I can tell you without doubt, most of the judges in Tennessee, when they're thinking about violating somebody's rights, they're thinking, is this guy going to go John Gentry on my ass? I guarantee that, and certainly my judge, I think he was under the influence of the bar. I think he was pressured to rule the way that he did. I think he's probably not a bad guy, but I think he got cornered. But I guarantee you, he's going to think twice before he does it to another person, because I've taken this thing all the way through to the Supreme Court, and I've got a strong case in the Supreme Court. And to deny me, the Supreme Court is going to have to commit treason against the Constitution if they're going to deny my case. And of course, I'm going to do a petition for rehearing, and they're not going to like what I write. So absolutely, Chris, great point. That just because they dismiss our cases doesn't mean that we're going to affect change. Randy Davis asked a question about, do any of us know mandamus? I know a little bit about it. Mandamus is when you're asking a higher court to order a lower court to do something, generally. Is that, Kirk, is that your understanding as well on mandamus? It's when you're asking a higher court to order a lower court to do something.
Correct.
Right.
So I'm actually working on, this is going to be my third case in the United States Supreme Court. And I'm happy to share this. I hope there's some trolls out there watching, because I'm coming, and figure out a way to keep me out of the record, because I think I'm going to get in the record. But I'm going to do a petition, an extraordinary writ in the nature of mandamus in the United States Supreme Court under Supreme Court Rule 20. And I'm going to say I can't get relief in any form in any other court. And so I got to come to you guys. So I'm going to do an extraordinary writ in the nature of mandamus to the Supreme Court. And I'm going to say, the Sixth Circuit and the Middle District, Tennessee, will not enforce the Constitution against bad actor state officials, particularly judges and legal professionals. And so I don't have anywhere else to go but to the Supreme Court. And there's a judge that violated my rights, made a ridiculous ruling that an idiot would know had no legal foundation whatsoever. And I'm going to go in and I'm going to say, Middle District, Tennessee has these rules of the court that are unconstitutional. So I can't go to them and have my case heard. I have to go to the Supreme Court because I'm challenging the local rules of a district court. And I'm going to challenge the local rules in the Sixth Circuit as well. The Sixth Circuit rules, I believe, are unconstitutional and were structured to deny due process. So I can't go to anybody else but the United States Supreme Court. So that's what mandamus is I'm going to ask the Supreme Court to void these unconstitutional rules. I'm also going to challenge some statutes that the state has enacted to protect corruption and that provide emolument and special privilege to public officials and persons in public trust. And we're going to see if the Supreme Court will hear that case. But that's what mandamus is asking a higher court to order lower courts or the state to behave constitutionally when they're not behaving constitutionally. So I hope that answered your question, Randy.
Well, I wanted to just say hi to a couple people that just came on. Sue Hardisher. She's one of my local people. I used to work for her and her husband. doing sprinklers, landscaping stuff. And Mark Cordry, good to see you on here, brother. Saw him this weekend at our rally down at the Capitol. Got to hear from some of our Idaho representatives and candidate elects. I think Ted Fogg over here has somebody who wanted to promote their event. I'm not sure if they're actually on the phone with us here. I'm not sure. We have last four digits, 3399. Who is that out there?
I'm gonna hit really quick on Joyce's comment that she should have the FBI investigating her case, but I don't trust them. The FBI website says that the Federal Bureau of Investigation is the premier agency to investigate judicial corruption, and they don't do squat. I mean, you call them up, they never call you back. They won't investigate. Absolutely useless. And you can see it in how they treat the Clintons differently than they treat the Trumps. The FBI is nothing, in my opinion. They seem to be a political arm. They are no longer acting in the interest of this country, I don't think. And I've worked with the FBI. By the way, I was a reconnaissance Marine, and I worked with some really great FBI agents in New York and in New Orleans. They were on the bank robbery task force. Excellent people in the FBI. Love them. But the higher ups, man, they're just a political arm, and they won't do crap. They're in league with the legal profession. They won't do anything to protect us. Maybe President Trump's going to straighten that shit out. I don't know. I hope he does.
Let's let Lydia in here and where did you go, Lydia?
Lydia's one of my local people here in Tennessee.
We're going to let you promote your deal there. Accidentally hung up trying to unmute. Well, darn it. Well, hurry up and call back in real quick. So, for those of you that tuned in late, you might want to go back and rewatch if you're interested in kind of getting an update on current events-ish stuff. And like the first half hour, 40 minutes there. And then John got into doing some different documents, writing different documents there, and which is going to be part of the norm from now on, is we're going to try and show people how to write stuff. So with that being said, let's bring Lydia on. I'll unmute you. All right, I unmuted you, Lydia. You're with us.
Hi, I was unmuting on my phone, and that's how I disconnected a second ago. But yeah, I just wanted to invite everybody to come to Nashville June 8th and June 9th, and we've got a event downtown Nashville. We're going to march around downtown. We're starting at the Supreme Court building where the Court of Appeals is, and we're going to go to the Capitol building and the historic courthouse and down to the Juvenile Justice Center. So we're going to hit all these places, and then at rush hour we're going to be standing out like on street corners. I'm going to try to spread people out, so we'll cover a lot of territory with signs. And then later we're going to, when it gets dark, we'll have a candlelight vigil, and this is for remembering baby Stephen Rivenberg, and his story was on medical kidnap. He was on life support. He wasn't brain dead, but he was on life support, and he was a Down syndrome baby, and I think he was costing too much money. And
yeah, I covered that a year ago. I covered that story.
Judge in Clarksville, Tennessee, gave the hospital authority to overrule the parents' medical decision making, and they took him off life support. And
so is this event, Lydia, to memorialize him specifically, or is there because I covered that event a year ago, the baby Steph.
Yeah, no, this is for the candlelight. It's for anybody, but it just June 8th is the date of it's the anniversary of his death, and it had so that's what's special about that. But I want to invite anybody, and if they want to send in a name of somebody who you've either lost contact with or who's died because of court corruption, I'd like to send me your name, and I'll or whatever names, and I'll read them. If you can't come yourself, I'll read them out during the candlelight vigil, because I mean, there's been an awful lot of tragedy involved in the corruption. And then on the Saturday, the next day in the afternoon, I've reserved a really nice spot at the Goodlettsville Public Library. We've got a big meeting room, and from 12:30 to 4:30, and we're going to have speakers and performers. Billy Elston and Joyce the Voice are planning on coming and singing. We have several speakers. Brian Kenter's going to be there. John Gentry's going to be there. I don't know if he's going to speak or not, but that's his hometown there, and it's right.
Home ground.
You ought to get him up on there. He's a good speaker.
Oh,
I know. I told him he's invited.
The Nancy Schaefer event with Ted Fogg and
yes. I would love for him to say to speak some about and it's so encouraging too, like what he just said about just because you lose your case, it doesn't mean that you're not making a difference, because every time somebody loses something, we learn something from that, because it's like, oh, if they find a loophole, then we can go next time we file something, we can plug it up. So I would love for but John's going to be there. Brian Kenter, Terry LaPointe, medical kidnapping. Ed Elliott, Ted Fogg, hopefully, Charles from Pennsylvania, and
I'd really like to meet
who
Charles.
else?
So is this the conference room you have? Is that in the evening, or are you talking about two separate days?
I'm talking about 2 days. The Friday event is going to be downtown Nashville, outside, and hopefully we'll have good weather. And the June 9th it's going to be inside. We've got a nice conference room, and I want people to bring their whole families. There's a playground at the school next door it's a community playground with the school's not in session. So bring your whole family, and I'd also like, if anybody's got children who want to speak up about how they've been adversely affected by family court corruption, anybody who's interested in this, just contact me, and we'll see if we can mention your story or have you come. But we've got a capacity, we've got 100 seat capacity. So that's, I think there were like 75 people in Georgia. So I'm hoping we'll bump it up just a little bit more. And so I think it's going to be a pretty amazing event. Georgia was good, and I think this is going to be even better. And it's the first thing like this that I haven't seen anything like this done in the past 4 years that I've been in this family court cesspool. So this is, I hope we'll have an annual event, but this is really special, and I hope people will come in from neighboring states too. But I shared the event page for the 8th and the 9th in the comment section of this on this video. So thank you for letting me share that.
And I want to say something about Lydia. She has been working so hard on putting this together, spending so much time pounding the pavement, getting people to come, getting speakers. We need more patriots like Lydia to help raise awareness and organize events around the country. And that's how we need to bring people together with these events. You know, when Ted put together the Georgia event and we actually brought people together from around the country, that was huge in itself. You know, for us to be face to face with each other and to strategize together. So we need more patriots like Lydia out there, you know, working to raise awareness and working to bring people together. So Lydia, God bless you. Thank you so much for all your hard work. I might speak on my home turf, but man, I'm scared.
No, dude, John, you're so awesome. It's not even funny.
I just
you did really good. You did really good out there in a foreign state.
No, I'm not afraid to speak. I'm of the nervousness or anything like that. I'm just afraid to speak on my home turf.
Hey, you got to get local. Local's where it's at. I mean, that's kind of where I've been at for a while now, trying to get with my local peeps. I mean, getting with some of my Idaho representatives, trying to get myself in there to help educate a little bit. And
I'm right there with John. I feel like in a way I'm hiding out in Vermont. I do most of my advocating in New Hampshire. My case is in Florida, so it doesn't really matter either way. But my home state is New Hampshire. That's where I grew up. And I know John didn't grow up in Tennessee, so in a way, maybe he's in the same boat as me, where he feels safe where he is. And if he's to speak up a little bit more, if I was to speak up, I talk about it in Vermont to legislators, but I don't do the type of advocating in Vermont that I do in New Hampshire, only because, in a way, I don't want that attention. So I
know what you mean, Ted.
Well, that's how I'm feeling that you're feeling. You know what I mean? So I understand that. But we're all going to be there, and we're all going to keep tabs on you. If anything happens, we have your video, your get-out-of-jail-free card, hopefully.
Right.
You know? Yeah. And everything's going to be okay. We're going to take care of each other. We're going to look out for each other. And eventually here, I'm going to have to do more advocating in Vermont, even though it's the 50th state in incentives received. Vermont isn't our number one enemy. I mean, but it is every state. But there is like the number one states are Texas, Florida, California, as far as incentives, Title 4D and E incentives received. Vermont is number 50, even though CPS in Vermont, according to a lot of people, like Peter Shemosnik, who is a great advocate, says Vermont is horrible. You know, eventually there'll be an event in Vermont, but I mean, we're talking about thousands of miles for most of us to get to Vermont. I mean, Vermont's out of the way. Anything I go to is hundreds of miles away, but is more centrally located for a lot of other people, like D.C., even Georgia is more accessible to people than Vermont is. So Vermont isn't a place that we need to worry about as much as some other places. Yeah. That's
interesting. Neely said maybe we should all start running for the legislature. And, you know,
we need to run either House or, you know, we need to run for representative or Senate.
Yeah.
You know, but
I'll tell you what, I would rather do that in New Hampshire than Vermont, but maybe I should just try it. The liberals in Vermont will run me out in an instant. You know, I have no chance.
I tell you, I bet you I can speak for all of us here. None of us want to be in this crap.
Yeah.
We all want to be doing our own thing. We don't want to be doing this, you know?
Nope.
But we have to. We don't have a choice. So, man, I don't know.
God put us here. I really believe that we are all in this. We are pieces of God's puzzle. If you believe in a higher power, whatever higher power you believe in, this shouldn't be happening. What is happening to children and families shouldn't be happening. What is happening to Americans in general, just in the lower courts, the way Sessions talked about it back in November, shouldn't be happening. Them creating legislation, bypassing the legislative process, is not only illegal to our Constitution, but is just it's fundamentally breaking our civil rights as human beings.
Mm-hmm.
So what we're doing is good. What we're doing is good for humanity, and everybody should be behind it. And I believe that God put us all here together to get along to end this. I really do.
Well, I'd like to put a thing out there to the other Ted, not Ted Fogg, the other Ted. I don't know if he's still on here, but
call in Wednesday.
There's some stuff in the background here, and that, you know, I've been following Trump since before his campaign. So when he started his campaign, and that's the reason why I'm wearing the hat that I'm wearing. Thank you, Glenita Zeiderfeld, for the hat. She's actually running down in District 25.
I love that name.
Idaho.
Glenita.
Idaho, representative, legislative. So, you know, Trump came out with a proclamation on December 8th, reestablishing the rule of law. And the very first part of it is, you know, through the fires of tyranny, and, you know, he flat out calls it out. There's no ifs, ands, or buts, okay? And then the December 20th, going after serious human rights violations and human trafficking. And then he dug that executive order up from the depths of 1984 about the military personnel arresting people. Okay, this is from 1984, which is part of what we can do anyway. That's why, you know, it's in there the way it is. But he amended it to bring in these military tribunals to go after military personnel to arrest civil servants, not the people, the servants. So, you know, and try them in these military tribunals, almost exactly the way we've been tried in these admiralty courts, because that's exactly, and I can tell you firsthand, I've been through one. And I'm not talking about the local courts, I'm talking about a military court. Because when I was in the Marine Corps, I had to go through one. So it was pretty much the same thing. Stand in front of a judge, he says one thing, I says another, and that's about it. Major made a decision. Luckily, I'm not the one that got in trouble because I wasn't in the wrong, but I was trying to pull rank on me and thinking, you know, we're in off-duty time and you're going to tell me to get off the phone? You can't do that. Kick rocks, dude. I don't care what stripes you got on your shirt over there.
Right?
We're not under any formation here, and we're not under drill, and we're not in combat. So,
well, you know, it's funny because, you know, my dad has joked with me over the years, you know, telling me, you know, you need to run for Senate. You're just too damn good at this crap, you know, and all of that stuff that he always tells me. And I'm like, well,
yeah,
that's neither here nor there. I can do a lot more to help more people being right where I am in the position that I'm in. So for me to go jump into that and just, you know, kind of end up being sucked into that thing without solving the problem, that kind of defeats the purpose just because the perspective from which I see it. And, you know, that's why I said in my original judicial report, it doesn't matter what the law says if they're not practicing it the way it's written and intended. You see what I'm saying? This has nothing to do with the law. The law's not broke. Don't fix it, right? It's about how they're practicing it. That's your problem.
I tell you, I'm having a hard time understanding how these people don't think that the Declaration of Independence is law.
Right.
Public defender, you know, I'm just like, did you pass?
Right? Well, you know, the ninth, and this is why I harp. I mean, I literally harp all over the Ninth Amendment, right? Because I'm going to read it to you. I mean, it's not rocket science. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people, right? Well, what is it when you walk into these tribunals that they're doing, that these judges are doing? They are misconstruing, right? That is literally reverse practicing. I can think of several different descriptive adjectives to it, none of which I would use in civilized conversation, but under the circumstances, let's just leave it as simple as, you know, it's in the practice. It's not in the law. The law works. The law is just fine. The science, I've worked through the science. The science is perfect. There's nothing wrong with it. It's just got to be practiced the right way. And that's where I do the most damage, is right smack in the middle of the practice. I know right where to drop the hand grenade. You know, and I'm having fun doing it. So that's why I do this. That's why I do what I do.
And God bless you for it.
So I love you guys, man.
Thank you all for tuning in tonight, folks. You can start rolling that, and we'll do our little 1 minute good night thing here.
Sorry I was late, guys.
It's coming, folks. Like I said, their Nuremberg trials took 1 week hanging. Yeah, it's coming. I'm praying. What do you got, John? Last minute words.
Well, I want to direct people to the Kirk's Law Corner YouTube channel. Ted's going to be loading up some little short videos, very informative. It'll be searchable. You know, how to do a motion for this or how to do a motion for that, and how to do legal research that we did tonight, how to ask a judge to recuse who's violating your rights that we did tonight. You guys go check out Kirk's Law Corner YouTube channel, subscribe. Ted's gonna be Ted. You know, you guys. You know, we just sit here and Ted does all the work. You know, he keeps us live. You know, to edit those videos is tremendous work. So, you know, big thanks to Ted. But go to the YouTube channel, Kirk's Law Corner YouTube channel. Kirk, maybe you can post that on Kirk's Law Corner. Start directing people over there. But it's going to be good stuff for you guys. Great informational source for you.
All right, Chris.
I just wanted to tell everybody again, don't forget the rest of the week. You got tomorrow night, we've got Far From Normal. Wednesday night, we're back. Thursday and Sunday, stop in and see Restoring Families Internet Radio. And who was on Friday, Kirk? Because I can never remember Friday.
I think it's Brian Kenter, Jam, In Your Face.
Is he back on Friday? Why was I thinking he was also on Thursday? Maybe it was just I was wrong. I don't know.
Yeah,
I haven't heard him in a while.
That's Blog Talk Radio, Future of Our Children Network.
Right.
Brian Kenter, Randy Davis, Rev It Up, Randy Davis. He's on Sundays. I know that one.
Right.
And definitely thank Mr. Ted Fogg over there for producing and doing what he does with magical hands and gadgets and gadgets and clickety click click, and he makes this stuff all happen and look great. Because those of you that have been tuned in long enough know the difference between when Ted's producing and when we're bare bones, I'm running OBS trying to make it work. So
right.
Thanks for hanging in there with us. We love y'all. Much love. Thank you.
Maybe by Wednesday I'll have our weather report. I'll have our weather window, look out a window ready to go.
So you are going to be with us Wednesday night?
I will be here Wednesday night.
Okay. Gary, one of a guy down in Twin Falls, he's 160 miles from me. Been trying to get me to help him, but you know what happened to me. I kind of got dumped on, and I'm still fighting right now. So I just went and filed paperwork today to start dealing with back over here. So on the roller coaster right now, on the fight. So
Wednesday, we will be discussing the space between spaces. All this stuff in here. That's what I'm going to be going over on the whiteboard on Wednesday, is the space between spaces. Tune in for that. It's going to be another very interesting thing. I show how this practice actually works and why it's been having the effects that it's been having. So tune in on Wednesday. I'll be doing that while we're waiting for callers. So
thanks, Ted Palmer. Thanks for the rest of you out there tuning in. Good to see some of more of my local peeps out there. Sue and Robert Harvester, Mark Cordy, Who else was? Lorraine. I did see you on there for a little bit. And obviously Gary. So anyway, Aaron Long's on here. Or at least it showed he's on here. Other than that, we will see you Wednesday. Stay tuned. Call-in show. Wednesday night's a call-in show. The number's right here on the screen. 1-408-638-0968. You'll call that number, and then it'll prompt you to enter this 376-657-800 to join. And then it'll go ding ding over here, and I'll hear you come in.
Y'all have a good night. Stay strong.
Much love. Good night, y'all.
Good night, everybody.